In today's video, we discuss the subject of corporate practice of medicine. Plenty of clients come to us having heard this very anachronistic term. They ask us to help them understand what it means for them. Corporate practice of medicine, right? So it has something to do with the big healthcare companies, maybe even the giants in the healthcare industry? Not quite, but we're going to unpack it together, make it very digestible. I'm Michael H. Cohen, founding attorney of the Cohen Healthcare Law Group. We've advised over 1,000 healthcare industry clients on healthcare and FDA legal issues. Today, I'm going to explain the ideas that motivate the corporate practice of medicine prohibitions all over the country. By the end of this video, you'll have a much clearer picture of what they might mean for you, and particularly what they might mean for you. Okay, in the United States, state laws restrict or sometimes outright prohibit a non-licensed person's ability to practice medicine. If you've watched some of our other videos, you might recall that we've used California laws as our examples many times, since we're principally here and many of our clients are here too. But corporate practice of medicine rules exist in some form all over the country. In some states, the corporate practice of medicine prohibition is contained in a statute. In other states, the prohibition is simply understood and enforced by regulators as an extension of the prohibition against unlicensed practice of medicine by an individual. Let's take the statutory definition of the practice of medicine as an example. The practice of medicine typically is defined in part as 1. Advertising or representing to the public in any manner that the person is authorized to practice medicine. 2. Offering or undertaking to prescribe, give, administer any drug or medicine for the use of another. Prevent or to diagnose, correct, or treat in any manner, by any means, method, device, or instrumentality, any disease, illness, pain, wound, fracture, infirmity, deformity, or defect of any person. These mean that a person cannot practice medicine without a valid state license. The rationale for the prohibition of such a practice, which is called unlicensed and corporate practice of medicine, is that unlicensed individuals or entities should not be practicing medicine or providing health care. The specific concerns include who has control over medical decision-making, commercial exploitation of healthcare, and the potential conflict of interest between the healthcare provider's loyalty to the employer instead of to the patients. Okay, that's public policy. Here are some specific risk mitigation strategies we use for those who are not licensed as physicians or other healthcare practitioners. If you're a non-licensed individual who is professionally involved with the healthcare business, it's of vital importance to note that your role is clearly separated from any clinical, medical component of the business. You must be careful not to weigh in or participate in treatment of any of the patients. You may have unique experiences that provide valuable insights to the situation, but you must be careful to recognize the limitations of your role and take care to develop boundaries to ensure that you're not perceived as practicing medicine, broadly speaking, with all the definitions above, doing any of the things from that list that we described earlier. Now, some states do have carve-outs for non-licensees who provide healthcare or healing services. For example, California has SB 577 or Senate Bill 577, which got codified into the California Business and Professions Code, and Minnesota has a similar law, which is actually known as the Minnesota Model for Non-Licensed Practitioners. These carve-outs are important, and we can make use of them in disclaimers and other written forms to help protect practitioners. We still have to be mindful, though, of the larger prohibition and definition of the practice of medicine, as this can be very broad. So beware of things such as interpreting lab tests. There are many more. This has been a quick jump into some of the laws affecting health coaches and other non-licensed practitioners. Thanks for watching. If you still have questions about how corporate and unlicensed practice of medicine rules could potentially impact you or your business, click on the link below, cohenhealthcarelaw.com/contact, to send us a message or book an appointment. Here's to the success of your healthcare venture. We look forward to speaking with you soon.